Historic, groundbreaking, a watershed judgment.
Make no mistake, this is a truly momentous day.
We know that we need urgent action on climate. This win in the Supreme Court today acknowledges that.
I think I found out what it feels like to go beyond your wildest dreams.
The judgment and victory for the campaigners clear, unequivocal.
That the Council's failure to assess the effect that burning the oil to be produced from the well site would have on climate means that its decision to grant planning permission for the project was unlawful.
Years of campaigning against Horse Hill, a Surrey oil field, were sometimes less genteel than the courts. Its proposed 6 wells could produce 3.3 million tonnes of crude over 20 years. The company said it didn't have to take into account the greenhouse gas emissions when that oil was inevitably burned. The council agreed, so did the Court of Appeal. Campaigners say that's like saying cigarettes are harmless so long as you don't light them.
What do we want? Climate justice!
And it went all the way to the Supreme Court judgment today. For leading campaigner Sarah Finch, quite a day.
I always thought the arguments we were making were right, but I don't know if I was confident that I thought that would translate into convincing judges. So it was a surprise. So I think to ordinary people it is bleeding obvious. And when Lord Leggett read out his statement today, I thought, well, yes, that's exactly what we've been saying for 5 years. Why did it take so long, and why did we have to go through all those other hearings in those other courts?
The implications profound, not least the key election issue of UK oil and gas. The court case over the proposed massive Rosebank oil field in the North Atlantic now looks, feels and likely is very different, says the lead KC in today's winning case.
There's a very direct impact on Rosebank because Rosebank was actually stayed behind this case. So the court recognised...
So they paused?
They paused that case. So the court recognised that the decision in this case will very fundamentally affect the decision in that case, because as I understand it in Rosebank, there was no assessment of the combustion emissions or the burning of the fuel that would be released.
Rosebank, 80 miles off Shetland in the North Atlantic. Campaigners say burning its oil and gas would produce more carbon than all the emissions from the 28 lowest income countries on the planet, including Uganda, Ethiopia and Mozambique. Rosebank and the North Sea Jackdaw gas field both on hold pending today's ruling, but now will either go ahead.
This ruling today, if drilling at Horse Hill is considered unlawful under these grounds, then I hope that it means that the same will happen for Rosebank and for Jackdaw.
The UK oil and gas licensing body called the court's ruling perplexing, but said they'd work to the new legal framework now in place. If you think this is all just legal, it's physical. The judgment comes after our winter and spring of lost UK crops due to incessant rains. Hundreds killed, thousands affected by heat stroke as India and Bangladesh suffer first extreme high temperatures and now extreme monsoon floods. Many people would see this as a 5-year struggle for a statement of the obvious. Consider it like this: if you were to open a chocolate factory and you said, well, the chocolates are 0 calories unless you bite any of them, people would say that is nonsense. In this case, an oil company wanted to drill a well and essentially seek to ignore the fact that someone somewhere would set fire to that oil and cause greenhouse gas emissions. Today, the Supreme Court decided that that too is nonsense. Campaigners say today also delivers yet another nail in the coffin of the proposed Cumbrian coal mine. It comes back to court again in July, with the legal landscape now profoundly shifted. Planners forced to account for the pollution its coal will cause. The North Sea, North Atlantic, Surrey, Cumbria, UK energy policy altered today by a short statement from the Supreme Court in London.
With me now is Estelle Dehon, who's a barrister with Cornerstone who represented Sarah Finch in the case, as you saw in Alice's piece there. Estelle Dehon, how far-reaching do you think this is today?
In some ways, it's not far-reaching at all, because it just clarifies a small area of law that requires certain information to be given to decision-makers. But in other ways, it's very far-reaching, because for those decision makers to take the decision with the full information about the full climate harm of extracting fossil fuel could change the dial significantly.
And change the dial on the Cumbrian coal mine, you know, the Rosebank and Jackdaw oil fields, as we've heard mentioned in Alex's piece?
Potentially so. Certainly in relation to the Cumbria coal mine, the argument was made that there are many processes in between the coal being extracted and the coal being burnt in the various furnaces. And the Supreme Court rejected that as a basis for differentiating or refusing to provide the information to the decision maker.
And of course, you're acting in that Cumbrian case as well. I mean, it does feel as if, doesn't it, that climate change campaigners have sort of lost faith in politicians to help them, and they've turned increasingly to the courts. Is that how it seems to you?
Not really. I think what the people that I represent and the organisations I work with have recognised is that the UK has a set of very clear climate and environmental legal frameworks, and that those apply in the climate arena. And what the courts are uniquely able to do is to understand how the law functions within the context of climate change. So the Supreme Court was very clear today to address the climate science, to address the way in which the law and climate intersect, and to understand that there are no legal principles, for example, that you can export climate harm. What the court stays away from is the policy and the politics, because of separation of powers.
You know, some might say that there's a risk that courts are sort of thwarting the will of democratically elected governments, whether that's local or national.
In fact, the Supreme Court was very careful to talk about the extent to which the need for this type of information about the climate harm from fossil fuel development was required for democratic legitimacy, for decision makers to take their decisions in a way that properly engage with the public and have that democratic legitimacy, because they will take into account the information that's provided and commented on in public participation.
It's very likely that in the next couple of weeks we'll have a new government. Now, obviously, Labour's said that it's not going to unpick oil and gas licences that have already been issued. But might this judgment change that? Might there be a way of unpicking recently issued licences, for example?
Well, the recently issued potential 100 new oil and gas licences were already before the courts. And there may be a way that, even though that case seemed to have come to an end fairly recently, this decision may change that. So there may be a small opportunity, though there's a very, very small window to open up already decided cases.
Right. And I mean, broadly, the sort of death knell for fossil fuels has been sounded. Business is taking heed, politicians less so?
That's not the way I see it. I think how I see it is that business is crucially good at understanding the risk, and that translates slightly more slowly into the politics. But I think the politics is recognising that it's far more risky to have fossil fuel and the potential stranded assets than to have renewables which are more durable.